In this video, we would like to discuss Article 42 of the Directive Principles of State Policy, which provides provision for just and human condition of work and maternity relief. So, the very provision give direction that states shall make provision for securing just and human conditions of work and for maternity relief. So, in that connection, the Union Parliament enacted Bonded Labor Abolition Act in 1976. Also, the Maternity Benefit Act in 1961. So, in that connection, we will discuss some important leading cases such as the first one, P. Shiva Swami versus State of Andhra Pradesh in 1988. Supreme Court observed that after repatriation to state of origin of bonded labor, the effective rehabilitation is necessary for fulfillment of purpose of bonded labor system. Abolition Act 1976. And now we'll go to the second one, that is relating to maternity benefit, and in that connection we will discuss the leading case, Municipal Corporation of Delhi versus Female Workers Master Role in 2000. Supreme Court expressed that Maternity Benefit Act 1961 is not applicable to municipal corporation as it was decided by the Supreme Court in 2000. And now we'll go to Article 43 and the very provision article of Article 43. The direction is given to state that states shall endeavor to secure by suitable legislation or economic organization or in any other way to all workers, agricultural, industrial, or otherwise work, living wage conditions of work, ensuring a decent standard of life and full enjoyment of leisure and social and cultural opportunities, and in particular, the states shall endeavor to promote cottage industries on an individual or cooperative basis in rural areas. So, in that connection, we would like to discuss certain important developments made in that regard by the union government, and that what exactly the directions given in this article to state was carried out by the government by legislating laws, so also by instituting and establishing certain important institutions such as the central government set up the Khadi and Village Industries Commission, so also the All India Handicrafts Board, so also All India Handloom Board, the Choir Board, Central Silk Board, and also Small Scale Industries Boards, and the small scale industries development organization at the center was entrusted the responsibility of implementing the policies of the government so far as the small industries were concerned. So, in that connection, we would like to discuss certain important leading cases. So, one is that Hindustan Machine Tools versus M. Rangareddy in 2000, Supreme Court expressed that where casual workers who were rendering services similar to government or to regular employment to company for over a decade should be regularized. And now we'll go to another important leading case, that is D.S. Nakara versus Union of India in 1983. Supreme Court expressed that classification in revised pension formula between pensioners on basis of date of retirement is arbitrary and violative of Article 41. And now we'll go to another article, that is Article 43A, and which was inserted under 42nd Constitutional Amendment Act in 1976, which exactly provides that participation of workers in management of industry. So the very direction given to the state that the state shall take steps by suitable legislation or in any other way to secure the participation of workers in the management of undertakings, establishments, or other organizations engaged in any industry. And in that connection, we would like to discuss important leading cases. So, regarding that, we would like to discuss All India Bank Officers Confederation versus Union of India in 1989. The Supreme Court expressed that the object of Section 9 of the Banking Companies Acquisition and Transfer of Undertakings Act 1970 is to empower the central government to make a scheme for the constitution of the board of directors so as to include representatives of the employees and other specified categories as it was pronounced by the apex court in this important leading case regarding workers' participation in management and the very important cases All India Bank Officers Confederation versus Union of India, and it was decided in the year 1989. And now we'll go to Article 43B, which was inserted under 97th Amendment Act, which was made in 2011, and the very provision regarding that is relating to promotion of cooperative societies. So, the very direction given to state that the state shall endeavor to promote voluntary formation autonomous functioning, democratic control, and professional management of cooperative societies. And now we'll go to another important article, that is Article 44, and the very direction to state under the article is given that the state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. So, in that connection, you discuss one important leading case, that is Panalal Bansilal Patil versus State of Andhra Pradesh in 1996. The Supreme Court pronounced that uniform law for all persons may be desirable, but its enactment in one go may be counterproductive to the unity of the nation. And it was pronounced by the Supreme Court, and such pronouncement as regarding the very unity of the nation would be affected, and according to the Supreme Court, it would be counterproductive to the unity of the nation in case of in one go by enacting a legislation for uniform civil code, as it was decided in this leading case, Panalal Bansilal Patil versus State of Andhra Pradesh. And now we'll go to another one important leading case, Maharshi Abhadesh versus Union of India in 1994. Supreme Court observed that, and here Supreme Court declined to grant a declaration nullifying the Muslims Women's Protection of Right and Divorce Act 1986. The court also dismissed the prayer to direct the government not to enact a Shariat Act so as to affect the rights of Muslim women. And in the same case, Maharshi Abhadeshi versus Union of India in 1994, Supreme Court dismissed a petition seeking a writ of mandamus against the government of India to introduce a common civil code. The court took the view that it was a matter for the legislature. The court cannot legislate in these matters. And in the same petition, Supreme Court granted declaration nullifying the petition that it could not give direction to the state to make laws in the matters pertaining to uniform civil code. And we will discuss another important leading case relating to uniform civil code as provided under Article 44, that is Renold Rajamani versus Union of India in 1982. The Supreme Court expressed that it rejected a prayer to remove the discrimination between men and women under Section 10 of the Indian Divorce Act 1869, which is applicable to Christians. The court based its approach on the limits of the court's jurisdiction. It held that when a legislative provision enumerates the grounds of divorce, those grounds limit the court's jurisdiction, and the court cannot rewrite the law so as to add grounds of divorce not permissible under the very section, and that is section 10 of Indian Divorce Act of 1869. So, in this video, we have completed up to Article 44, which deals with Uniform Civil Code, and in our upcoming video, we will discuss Article 45, Article 46, Article 47, Article 48, and Article 48A, which was inserted under 42nd Amendment Act 1976, and that we would like to discuss in our upcoming video.